Namaste. Dear students, we have come to the end of discussion on the consumer protection and the related laws in India. During the last so many lectures, we tried to understand the concept of consumer protection, the position before the independence, the position under the Consumer Protection Act of 1986, now under the newly enacted law, that is the Consumer Protection Act of 2019, then the consumer protection in specific areas, the rights of the consumers, the mechanism for redressal of the grievance of consumers, so on and so forth. In this lesson, we shall try to understand some of the emerging trends in the area of consumer protection with special reference to India. In recent times, there has been a paradigm shift in the landscape of consumers, the nature of goods and the services availed by them, the mode or channels of consumer services, the methods of redressing their grievances, and the organization of consumer rights groups and organizations. It is due to the impact of globalization, which made the society a global village, and the digitalization, which has contributed to the phenomenal growth of e-commerce. In order to keep pace with the fast changing needs of consumers and to ensure their protection, the governments of the date have been bringing in new laws and procedures. In this lesson, let us understand some of the important and emerging trends in consumer protection. First, Central Consumer Protection Authority (CCPA). With the growth of online marketplaces and India's growth as a consumer economy, the government brought into existence a new Consumer Protection Act in 2019, replacing the earlier one made in the year 1986. The biggest change brought about by the new law is the establishment of the Consumer Protection Authority at the central level, called CCPA. The authority, besides being tasked with promoting consumer protection, shall also have the power to enforce consumer rights. Its powers and functions have been discussed in detail in earlier classes, but the fact remains that this authority can act as a super regulator and consumer watchdog in protecting the rights of consumers in India. Now, yet another recent development is e-Dakhil, which is the online complaint mechanism. The consumers need not physically come to a consumer court to file the grievance. Now, they can file the complaint online through e-Dakhil portal, which was introduced on September 7, 2020 during the COVID-19 pandemic. It is developed under the Consumer Protection Act 2019. It has a provision of online filing of consumer complaints in the consumer commissions and online payment of fees for filing a complaint. Under the 2019 Act and during the COVID times, it was the need of the hour to facilitate the consumer by online filing to battle the pandemic situation. It is very vital, as through this portal all the deprived and aggrieved consumers will be able to file the consumer complaints in the consumer commissions online from anywhere at the comfort of their own, and also pay the complaint fee and monitor the status of the cases online. Till now, e-Dakhil portal has been launched for the National Commission for the redressal of consumer disputes on 7th September 2020, and thereafter the facility is launched in 23 states and union territories for respective state commissions and district commissions. Any consumer or advocate can register themselves on the eDakhil software with proper authentication through a one-time password sent on their registered mobile or activation link sent on registered email ID. Thereafter, they can proceed for filing a complaint. The eDakhil has also been integrated with the Common Service Centers, that is CSCs, a mission mode project under the Digital India program to make public utility services accessible to residents of remote and rural parts of the country. A consumer got speedy justice early this year with the help of the government's eDakhil facility after getting cheated with a defective saree worth rupees 16,900 from a shop in Aligarh, Uttar Pradesh. Another consumer complaint was redressed through the same eDakhil facility in Chandigarh for a defective combo set of cast iron tawa and cast iron skillet single handle for rupees 1,529 from a website. As on 31st August 2022, a total of 84,657 users got registered, 23,640 complaints were filed, 5,590 complaints were admitted, 889 cases were disposed, and 4,701 cases are still pending in eDakhil. Another change is effectively dealing with misleading advertisements. Advertisement mean any audio or visual publicity, representation, endorsement or pronouncement made by means of light, sound, smoke, gas, print, electronic media, internet or website, and includes any notice, circular, label, wrapper, invoice or such other documents. This is a new definition under the new consumer law. More often, we come across the celebrities endorsing certain products as brand ambassadors or otherwise. The 2019 Act clearly defines an endorsement as any message or depiction which makes the consumer believe that it reflects the opinion, finding or experience of the person making such endorsement. The Act empowers the CCPA to hold an endorser of a particular commodity personally liable in the event of such misleading advertisements, especially when they are endorsed by reputed personalities, influencers on social media websites like Instagram and celebrities. Misleading or deceptive advertisements include puffed up advertisements, which include praising or describing the item to be sold using subjective opinions, superlatives or exaggerations, vaguely and generally stating no specific facts. Example: best, better choice, world's most effective, so on and so forth. In order to protect the consumers from the influence of false or misleading or puffed up advertisements, the 2019 law has made adequate provisions. Now, the CCPA can impose a penalty of rupees 10 lakh on not just the concerned manufacturers or traders, but also on the endorsers themselves. In addition, the endorser could be prohibited from endorsing any product for a period of 1 year for the first offence and for 3 years for subsequent contraventions. The Act also prescribes increased fines and even imprisonment for the manufacturer for misleading endorsements, which is a higher term for subsequent ones. However, it exempts the advertiser from personal liability in situations where the advertiser has shown reasonable efforts to verify the genuineness of the product advertised. When we look at the penalties for misleading advertisements under the new act, the manufacturer may get jail imprisonment up to 2 years with a fine up to rupees 10 lakhs for first offence, and an endorser may be fined with an amount up to rupees 10 lakhs and 1 year ban on future endorsement for first offence. And even publishers and advertisers are also punishable with fine up to rupees 10 lakh if Central Consumer Protection Authority finds the publisher or advertiser guilty. And in this age of puffed up advertisements and false promises, we often come across statements like black hairs in just 15 days, scars removed at once, get fair skin. All of them are misleading, and the consumers are required to be aware of the misleading advertisements and their evil effects. The regulatory authorities in case of false or misleading advertisements include Department of Consumer Affairs, which maintains a portal called Grievances Against Misleading Advertisements; Advertising Standards Council of India, which is a self-regulatory voluntary organization of the advertising industry established in 1985; the Consumer Complaints Redressal Council, which is a part of Council for Fair Business Practices that was set up in late 1960s by a group of eminent businessmen such as J.R.D. Tata, Ramkrishna Bajaj, Arvind Mafatlal, S.P. Godrej and others. Another trend in modern times regarding the consumer protection is recognition of product liability. The 2019 Act for the very first time recognizes product liability as a core area of focus for consumer protection. It refers to the liability of a manufacturer, service provider or seller to compensate a consumer for the harm or injury caused by any defect in goods or deficiency in services. The liability for manufacturers is stricter as compared to that of service providers or traders, since the Act provides for product liability even if they are able to prove that they were not negligent or fraudulent in making the express warranty of a product. E-commerce transactions and consumer protection. Electronic commerce, popularly known as e-commerce, is the buying and selling of goods and services or the transmitting of funds or data over an electronic network, primarily the internet. These business transactions occur either as business to business B2B, business to consumer B2C, consumer to consumer C2C or consumer to business C2B. The terms e-commerce and e-business are often used interchangeably. E-commerce has deeply affected everyday life and how business and governments operate. Commerce is conducted in electronic marketplaces and in the supply chains working in the internet web. Consumer oriented marketplaces include large e-malls such as Amazon, consumer to consumer auction platforms like eBay, multi-channel retailers such as LL Bean and many millions of e-retailers. Massive business to business marketplaces have been created by Alibaba and other companies. Mass customization of goods sold online such as garments and vehicles became common. In fact, almost all the fast moving consumer goods are traded through e-commerce platforms nowadays. Under the Consumer Protection Act 2019, the Consumer Protection E-commerce Rules 2020 have been formulated. This act introduced significant changes to the 1986 Consumer Protection Law to address the unique issues arising in this era of digitization and e-commerce. The e-commerce rules provide a framework to regulate the marketing, sale and purchase of goods and services online. The e-commerce rule apply to all goods and services, including the digital products transacted over an electronic or digital network, and all models of e-commerce, including marketplace and inventory models, and all e-commerce retail and all forms of unfair trade practices across all e-commerce models. Further, the e-commerce rules have extraterritorial application on those e-commerce entities which may not be established in India, but systematically offers goods and services to consumers in India. E-commerce entities are required to mandatorily register themselves with DPIIT, that is Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India, and display their registration numbers prominently to their users on their platform as well as the invoices. Introduction of ADR method in resolution of consumer disputes. ADR system, that is alternative dispute resolution, primarily consists of arbitration, conciliation, mediation and negotiation. It has been assuming increased significance in recent times. Mediation is an out of court settlement where the parties can decide the manner of the proceedings. It helps the speedy settlement of disputes. The Consumer Protection Act 2019 has introduced the provision where the relevant commission can refer a consumer dispute for mediation when there is a scope of settlement between the parties. However, parties to the mediation are given a time frame of 5 days to accept or reject the process of mediation, as consent is vital for it. Once a dispute is referred to mediation, the fee paid to the commission for dispute redressal is refunded to the parties. According to the Consumer Protection Act, a consumer mediation cell shall be attached with all the dispute resolution forums at district, state and national level. The Act further states that if upon the admission of complaint, the forum feels that if the complaint is fit for mediation, then it can direct the parties to undertake mediation, and the parties have to send their written consent to undergo mediation within 5 days. Upon the receiving of consent, the forum shall send the complaint to mediation cell within 5 days. As per the Consumer Protection Mediation Regulations 2020, the entire mediation process shall stand terminated on expiry of 3 months from the date of first appearance before the mediator, unless the time for completion of mediation is extended by the Consumer Commission, in which case it shall stand terminated on expiry of such extended time. The agreement reached between parties is then sent to the Commission in a sealed cover. If no agreement is reached, the reason stating so must be accordingly sent to the Commission. This development can save the money and time of consumers while getting their grievances redressed. In its landmark judgment of Afcons Infra Limited versus Messrs. Cherry and Workey Constructions, decided in 2010, the Supreme Court divided cases into categories: suitable includes consumer disputes and unsuitable for ADR methods. The court observed the potential of ADR methods to provide speedy and effective redressal of litigants and its further impact in reducing the pendency of cases in courts. Thus, the introduction of mediation under 2019 Act should be considered as a welcome step, as it could act as a tool to tackle backlog in consumer cases. Anti-competitive practices and consumer protection. These practices are business or government practices that prevent or reduce competition in a market. Antitrust laws are formed to promote healthy competition within a free market by limiting the abuse of monopoly power. Competition allows the companies to compete in order for products and services to improve, promote innovation, and provide more choices for consumers. In order to obtain greater profits, some large enterprises take advantage of market power to hinder survival of new entrants. Anti-competitive behavior can undermine the efficiency and fairness of the market, leaving consumers with little choice to obtain a reasonable quality of service. In recent years, there has been a realization among the consumers about the ill effects of anti-competitive practices. Anti-competitive practice or behavior is used by business and governments to lessen competition within the market, so that monopolies and dominant firms can generate supernormal profits and deter competitors from the market. Therefore, it is highly regulated and made punishable by law in cases where it substantially affects the market. On 29th March 2023, the National Company Law Appellate Tribunal (NCLAT) upheld the order of the Fair Trade Regulator, that is the Competition Commission of India, of imposing a penalty of rupees 1,337.76 crore on the internet giant Google. On August 20 last year, the Competition Commission of India slapped a penalty of this amount on Google for anti-competitive practices in relation to Android mobile devices. About 97% of the 600 million smartphones in India run on Android, according to Counterpoint Research estimates. The NCLAT's order has largely confirmed CCI's other findings from last October, that the said Google abused its market dominance in the Android ecosystem. It held that mandating pre-installation of its entire Google Mobile Suite (GMS), a family of key Google apps and services such as Google Search, Chrome browser, YouTube, Google Maps and Gmail, amounted to imposing unfair conditions on OEMs, which is an abuse of dominant position by the company. By bundling products like its search engine or the Chrome browser, Google had perpetuated its dominant position, the NCLAT said. Emergence of mass tort actions in consumer protection. Simply stated, when a lawsuit involves multiple plaintiffs against one or more defendants, it is known as a mass tort action. In other words, a mass tort is civil litigation that consists of a single accidental or intentional action that causes many people to sustain injuries. The biggest benefit of joining a mass tort claim is that it increases your chances of recovering damages from entities such as product and pharmaceutical manufacturers. In consumer protection, a significant number of mass tort cases involve some form of negligence. The main categories are as follows: medical device injuries in case of defective products that fall below the industry standard and cause patients to sustain serious injuries and even death. The types of injuries caused by defective medical devices include heart attack, organ loss, allergic reactions, permanent disability, chronic pain, tissue or bone damage, infections and stroke, prescription drug injuries and also product liability injuries, etc. In recent times, Johnson & Johnson's baby powder case in USA has been a popular mass tort action. According to the World Health Organization, asbestos exposure is a health risk with potentially carcinogenic effects. The talc in Johnson & Johnson's baby powder has been shown to contain trace amounts of asbestos, which are a natural byproduct of some talc products. In 2018, Johnson & Johnson was ordered by a St. Louis jury to pay $4.7 billion to women who developed breast cancer while using their products. This massive settlement opened the floodgates for lawyers looking to push for punitive damages in mass tort litigation. In another case, that is Monsanto's Roundup, the first federal Roundup trial took place in February 2019. Hardeman versus Monsanto, in this case where a California man developed non-Hodgkin's lymphoma after decades of exposure to Monsanto's best-selling weed killer Roundup. It concluded the following month with a verdict of $25 million for the plaintiff. Another case, Pilliod et al. Versus Monsanto, took place shortly thereafter, lasting 2 months, leading to even a larger verdict against the company to an extent of $86.7 million. In total, Monsanto, which has become Bayer now, has lost 3 cases over its Roundup product being linked to cancer. The amount of Roundup claims has reached 18,000 and the litigation is ongoing. In a new legal strategy, Bayer requested a delay for the second round, pushing the trials back several months to January 2020. The delay is providing extra time for settlement talks. We can expect similar litigation in India also in the coming years, given the increased awareness of their rights by the consumers. To conclude, it may be stated that great changes are taking place in the landscape of consumer protection. The new forms of defects in goods, deficiency in services, the mode of availing those services or purchasing the goods, the new methods of dispute resolution and the new kind of litigation like the mass tort action, all of them are electrifying the field of consumer protection. I sincerely hope that the students have followed all the lessons on consumer protection, including the present one, which will throw light on some of the emerging issues.